Hello and welcome back to Career Success Strategies, Lesson 7, Part 3, Article 23A and Fair Chance Act. In this lesson, we will discuss the two pieces of legislation both New York City and New York State put into position to widen the gap of employment for individuals with a criminal history. And there is a lot of content in this video, so please feel free to pause the video at any time and take notes or read through the slides more thoroughly. Let's begin. Article 23A is a New York state law that declares that employers cannot refuse to hire or retain you just because you have previously been convicted of a crime. And employers, both public agencies and private sectors with 10 or more employees, must carefully consider 8 factors when deciding whether to hire someone with prior convictions. And they have to evaluate applications from job seekers with prior convictions on a case-by-case basis. Now, anyone who has read a piece of legislation, I'm sure can agree that it can be extremely comprehensive. So we took the piece of legislation and outlined the 8 factors. And as we go through them, I want you to think of what factors may be in your favor. Number 1, time elapsed since conviction. The further the back, the better. The more time you'll have had to engage in positive rehabilitative activities, work, training, school, community services. Think about what you're doing right now at the Doe Fund. Are you working toward your high school equivalency? Or are you enrolled in any occupational trainings? Number 2, age of applicant at the time of offense. An adult's brain is not fully developed until 25 years of age. So it's not uncommon for someone who exercised poor judgment as a youth to mature into a productive, hardworking adult. Number 3, evidence of rehabilitation and good conduct. Education, references, participation in programs, workforce development, counseling, social services, and volunteering. Certificates of relief and good conduct are both evidence of rehabilitation and must be factored into hiring decisions. Number 4, seriousness of conviction. The title of the criminal conviction is not the end of the story. Take into account the circumstances of the crime. A robbery charge could be a teenager taking another teenager's book bag off of his body to toss it around, or it could be something much more serious. Number 5, specific duties and responsibilities necessarily related to employment sought. Can the applicant do the job? Does he or she have the skills and certifications required? Number 6, the bearing the offense has on the applicant's fitness and ability to perform the job duties. Do the job responsibilities share any qualities with the activities that led to convictions? Examples, credit card fraud convictions may not be a good fit for a bank job, or a DUI conviction may not be a good fit for a driving position. Number 7, public policy considerations. New York State encourages employers to hire individuals with prior convictions. And number 8, legitimate interest. Would hiring this specific applicant pose a legitimate risk to people or property? Employers must decide this after considering all of the factors. The conviction itself is not a legitimate reason. There are only 2 justifications under Article 23A for an employer to deny you a job based on your past convictions. Number 1, if there is a direct relationship between the criminal offense committed and the employment sought. A direct relationship exists if the nature of the criminal conduct directly bears on the fitness or ability of the applicant to perform the duties or responsibilities of the job. And 2, if the applicant would pose an unreasonable risk to property or the safety or welfare of others. This includes a risk to specific individuals or the general public. So let me give you a few examples. If you've been convicted of drug distribution, you may not be able to work in a pharmacy. And if you have been convicted of child abuse or negligence, you may not be able to work in a school. The New York City Fair Chance Act makes it illegal for employers to ask about your criminal record until after offering you a job. And this law went into effect in New York City on October 27, 2015. Now, for job seekers, it allows people with a conviction history to be evaluated on their merits, and it removes unnecessary barriers to employment. For employers, it provides a broader range of applicants to consider, and it maintains safety and security on the job. Now, although New York state law already said that employers cannot use unrelated convictions when making employment decisions, by asking about convictions on an application, many employers rejected applicants who indicated that they had a record. And this means that more than 5 million New Yorkers lost the opportunity to demonstrate their qualifications and get a chance to explain the circumstances of their convictions. So this bill tried to ensure that all, both public and private employers, considered applicants based on their skills, experience, and qualifications before weighing whether their conviction history is relevant. It bans job ads that say things like no felonies or must pass background check. It bans any questions about criminal history on job applications. It bans any questions about criminal history during job interviews. And an employer can check your criminal record history only after a conditional job offer has been extended to you. All employers in New York City with 4 or more employees must obey the Fair Chance Act. They have to follow it when hiring, promoting, demoting, or firing people. The law does not apply to some jobs, like police officers, and any job where a law says that people with certain convictions cannot do that job. Employers that are required by law to conduct background checks and exclude people with specific convictions may still do so. And it's important to note that employers may still conduct criminal background checks and deny employment to workers with conviction histories that are directly related to the job or pose an unreasonable risk. So if you are denied a job because of your criminal record, the employer must explain why in writing. They must explain how your criminal record history connects to job duties or shows it creates an unreasonable risk. The employer must also hold the job open for 3 days so you have time to discuss the issue or correct any wrong information. This is why it's so important to obtain your rap sheet and correct any mistakes as soon as you can. It minimizes the chances of the employer getting incorrect background check information. And if they do, and you already have your dispositions, you can move more quickly and provide that documentation to them. Unfortunately, not all employers are aware of or follow these laws. And in the next lesson, we'll talk about your options in answering questions about arrests or convictions during the interview process. Congratulations! You have successfully completed Lesson 7, Part 3 video. Now, to finish this lesson and get credit for this session, please return to the Google Classroom classwork page and take the Lesson 7, Part 3 assessment, Article 23A, and Ban the Box quiz. Good luck!